Managing data privacy risk for life science companies. Diana Mayer is the founding partner of Mayer Law Group, MLG, a boutique employment and data privacy law firm based in Marin County that services primarily life sciences, health services, and high-tech clients. Diana graduated from Stanford Law School in 1998 and worked as a public defender in San Jose for several years before starting her own firm. Diana serves as contracted in-house counsel in the areas of employment and data privacy law for a large Silicon Valley company. She and her firm also provide employment defense litigation and advice and counsel services in both employment and data privacy law, as well as conduct workplace trainings and investigations. Carolyn Bruguera is an attorney specializing in healthcare compliance advice to medical technology companies. She has a private practice in Belmont, California, and also serves as general counsel to the Medical Device Manufacturers Association. Carolyn started her career as a corporate and securities lawyer in Silicon Valley, where she was in private practice for 12 years before joining the medical device industry. She has held 2 public company general counsel roles with Micros Endovascular and Hansen Medical. Carolyn received her AB magna cum laude from Harvard University and her JD from UC Berkeley Bolt Hall School of Law. Eric Towsend is an assistant vice president for ABD Insurance and Financial Services Executive Protection Services team. Prior to joining ABD, Eric spent 5 years as an insurance recovery attorney at Farella Braun and Martel. Eric focuses on innovative and efficient insurance solutions and risk management strategies for clients. Eric specializes in directors and officers liability, D&O insurance, for publicly traded companies and private companies working to go public. Eric received his JD from the University of California, Hastings College of the Law, magna cum laude. Based in San Mateo, California, with multiple offices in the Bay Area and Seattle, ABD is a consulting firm providing risk management, insurance brokerage, human resources, and retirement consulting services. To learn more about ABD, visit www.theabdteam.com.
We believe you will benefit from today's webinar and hope that it will help guide you as you make decisions pertaining to managing data privacy exposures. Today's topics of discussion are how and when HIPAA applies to life science companies, examples of current government enforcement, the new general data privacy regulation, how to safely and legally conduct transfers of data from the EU to the US using the health data exception, approaches to managing cybersecurity risk, cybersecurity and the board of directors, fiduciary duties and governance. We encourage you to send in your questions throughout the presentation, and we will open the session up for Q&A at the end of the presentation. The panelists are also happy to answer any questions you may have if you wish to contact them directly. Thank you.
So we're going to start with HIPAA, which is a very big and expansive set of laws and regulations. But the essential elements of HIPAA are probably somewhat familiar to most of you: the privacy rule, the security rule, and the enforcement rule. The privacy rule requires that a covered entity may not use or disclose protected health information without patient authorization or individual authorization, to use the words of the regulations. There are a number of important exceptions to this rule. For example, and perhaps obviously, a covered entity can provide an individual with their own protected health information. There's an exception that covers a number of situations, which is disclosures for treatment, payment, and healthcare operations, which we'll talk about a little bit later. Disclosures with an opportunity to agree or object are also accepted from the requirement of obtaining individual authorization. So for example, if you're in an in-person situation and your healthcare provider discloses information to somebody else in front of you where you have the opportunity to object, they do not have to get your written authorization to do that. Disclosures that are incidental to an otherwise permitted use are also permitted without written authorization. And one of the examples that HHS has provided is the situation where a janitorial service might incidentally see some patient information in performing their obligations while the hospital personnel are going about their business. And this would not be something that requires written authorization of a patient. There are public interest and benefit activities. This includes safety issues, adverse event and product disclosures and things like that, which we'll talk about a little bit later as well as the disclosure of a limited data set for the purposes of research, public health, or healthcare operations. In addition, under the privacy rule, covered entities are required to disclose PHI in certain situations to patients who request access to PHI or to HHS in connection with its compliance and enforcement activities. The security rule requires covered entities to maintain reasonable and appropriate administrative, technical, and physical safeguards to ensure the confidentiality and integrity of electronic patient or protected health information and its availability to individuals who request it. To protect, identify and protect against reasonably anticipated threats, to protect against reasonably anticipated and permissible uses and disclosures, and to ensure compliance by an entity's workforce. And so this covers the policies and procedures that covered entities need to have in place and the requirement of periodic risk assessments. The enforcement rule contains provisions relating to compliance, investigations, and hearings, and imposes civil monetary penalties, as well as, under the HITECH Act of 2009, criminal penalties. The HITECH Act also increased the previously existing penalties and imposes them on business associates as well as covered entities. So who has to comply with HIPAA? First and foremost, covered entities, which includes healthcare providers who transmit PHI electronically in covered transactions. This is actually an important distinction. Most healthcare providers, as we think of the term, are covered entities, but that's actually because they transmit PHI electronically in the types of transactions that trigger HIPAA, including in connection with making claims for insurance payment or submitting claims to Medicare. Health plans and healthcare clearinghouses are also covered entities. Business associates are entities that perform specified functions or activities involving use or disclosure of PHI on behalf of or that provide services to a covered entity. So when is HIPAA an issue for life sciences companies? Well, a life sciences company can be subject to HIPAA. It can actually be a covered entity. If you provide healthcare services and supplies and transmit PHI in covered transactions, such as billing Medicare or other payers, you can be a covered entity. That does not apply to most life sciences companies, but it can apply, for instance, to a DME supplier, durable medical equipment supplier, or a clinical lab services organization that bills Medicare directly, for example. And those are just examples. Generally, however, a life sciences company is not a covered entity. But increasingly, we see companies becoming business associates. Sometimes that's because they really are business associates, and sometimes it's because they're being asked to sign business associate agreements. But one way or another, companies are subjecting themselves to HIPAA requirements. There are a number of practical issues that HIPAA raises for life sciences companies, including the conduct of clinical trials, which we'll talk about in a minute, marketing activities, product support, which often involves having access to PHI, business associate agreements, and the obligations that companies sign up to when they sign those agreements. Typically, sponsoring a clinical trial does not make a company a business associate. As we already noted, there is a specific exception for research built into the privacy rules. Moreover, it's not always necessary for healthcare providers to disclose individual patient information in connection with working with a sponsor on a clinical trial. But to the extent it is required, that's typically covered by the terms of a clinical trial agreement or a data use agreement outside the scope of HIPAA. So although there's a general rule that healthcare providers that are covered entities have to obtain individual authorizations to disclose PHI, in the context of a clinical trial, there are a number of exceptions that again make HIPAA not, or at least make the sponsor not a business associate. The IRB or Privacy Board waiver is another common reason that individual patient authorization is not required. The information that's transferred is often de-identified. There are specified activities preparatory to research that are accepted, and as already noted in the privacy rule, a limited data set does not require patient authorizations. Another issue that comes up a lot for life sciences companies is marketing activities. The rule under HIPAA is that a covered entity may not use or disclose information for marketing purposes without an individual's written authorization. There is a huge exception in that rule, which is that a covered entity can provide information about its own products and services to its patients without violating this rule. So for example, a hospital can do a mailing to all of the patients at that hospital to tell them that it has new equipment or that it's offering a service. There are also communications for treatments of individuals that are accepted, and this includes prescription refill reminders, which very often pharmaceutical companies pay for. In addition, face-to-face marketing doesn't require individual authorization, and providing modest promotional gifts does not require this. However, and this is very important to understand, third-party financial support can affect the above. So the minute a life sciences company pays a physician to communicate with its patients regarding products and services, even if they are products and services offered by that physician or by that hospital, those are no longer accepted unless the payment, in the case of communications for treatments of the individuals, is just the cost of actually making the communication. As a result, it is common for pharmaceutical companies to pay for prescription refill reminders as long as they're only actually paying for the cost of sending the communication. But if a life sciences company wants to pay a healthcare provider to inform all of its patients that, for example, the products of that company are now available through that provider, they would not benefit from this exception. It's important to understand that not all activities require a business associate agreement, and the reason it's important to understand this is that increasingly healthcare providers want everybody who walks in their door to sign a business associate agreement. This is certainly a challenge for a number of the medical technology companies I work with. One of the most important exceptions to the privacy rule, as I already mentioned, is treatment disclosures related to providing healthcare. So if the company that a disclosure is being made to is acting as a healthcare provider in connection with the disclosure, they are not a business associate. In the medical device world, this includes the situation where a representative of the company is in the operating room, for example, and is providing technical product assistance to the healthcare provider. So for example, for an orthopedic company, they might have reps helping the physicians choose the right size of implant. They might be right there in the operating room or just outside, and they don't have to sign a business associate agreement for that purpose. Disclosure for payment of a healthcare provider is also accepted. This is the payment operations exception from the privacy rule. And this is a little bit complicated. If a covered entity is making disclosures, for example, they're seeking reimbursement for a service, they don't have to get a patient authorization for that purpose. And that can protect a life sciences company too in connection with their payment operations. It does not necessarily cover the situation where the life sciences company is helping the covered entity, the provider, obtain their payment though. So you do see entities signing business associate agreements in connection with reimbursement support. Public health disclosures are another exception, as we've discussed. So reporting adverse events or quality problems do not require patient authorization, even if you have to disclose patient information. And as we already discussed, sponsoring clinical research should not require a BAA.
Nevertheless, just say one thing here, Carolyn. It does seem like there's a real movement right now to ask everybody for a BAA. I'm wondering if you see that a lot in the life sciences. I mean, I see it just advising law firms that they're, even when they're not getting PHI, they're often asked to sign BAAs. And we have to
That's an interesting point, because a law firm can be a business associate, but if they're not receiving and don't need to receive PHI, they don't have to sign a business associate agreement. So I think what probably happens is some companies or some covered entities want to make sure that in case down the road some PHI gets disclosed, that they're covered. And one of the reasons for this is that HHS has announced that they are concerned about this, and this has been a topic of audits in the last few years, and there's been enforcement around failing to have business associate agreements in place. And so the downside is that covered entities may be overbroad. And I have still seen in most situations, the companies I work with are able to avoid signing business associate agreements when they point out that they really don't have to, often in writing. But it does seem like it's coming up more often than it used to. So when you do have to sign a business associate agreement, you should take a look, and I've got the regulatory side in here, to make sure that it's narrow, that it's not requiring more than you actually have to agree to comply with the law, or to enable the covered entities to comply with the law. And you should also make sure that it only relates to the activities for which the business associate agreement is required. You really don't want all of the PHI that you may have access to as a result of your activities to be covered by the business associate agreement when it really only needs to cover a narrow set of those activities. So if you are, for example, a medical device company and you are providing product support that gives you access to PHI, but you're also engaged in activities that make you a business associate, you'd like to make sure that your day-to-day activities that don't require a BAA aren't swept into that agreement unnecessarily. And the other perhaps obvious pitfall of a business associate agreement is the failure to manage it. Companies may sign these because they want to do business with a hospital, for instance. But when you are signing that, particularly since 2009, you are actually agreeing to real obligations and real exposure. So what are the obligations that business associates actually have? Clearly, you need to limit use and disclosure of the PHI you're gathering pursuant to the, or have access to pursuant to the agreement to a minimum. You must conduct a risk analysis. You should appoint a security officer. When I say must and should, the standards that HIPAA applies are, there are some mandatory requirements and there are some standards that, if not really required based on your risk assessment and the type of information you have access to, you can sometimes avoid. But you must implement technical, administrative, and physical safeguards, including HIPAA policies and procedures. You must train affected personnel. You must enter business associate agreements with subcontractors that require PHI that's covered by the BAA that you're subject to. So to the extent you have to give that information to subcontractors, you need to have them sign a BAA. You must be able to provide PHI to the covered entity or individual and you're subject to breach notification requirements. Normally, a business associate only has to notify the breach to the covered entity that then has the obligation to, in certain circumstances, to inform the individuals or HHS or the media. But depending on what your BAA says, that obligation or the cost of it could fall on you. So that's something you want to look at carefully in your business associate agreement. HITECH in 2009 had a big impact. Business associates are now directly liable for HIPAA penalties, must perform periodic audits, are subject to breach notification requirements, as I mentioned, and to new penalties, and there is now criminal liability. Very briefly, I'm just going to touch on some recent HIPAA enforcement. June 2016 was the first time a business associate had to pay a penalty and enter a corrective action plan under HIPAA, and then there was another one in September. So that just shows the new trend of enforcement against business associates. There were also several settlements in 2016 and 2017 for failure by covered entities to enter business associate agreements, which I mentioned when Diana asked about this disturbing new trend in everybody being asked to sign a business associate agreement. That's probably why. I also just wanted to flag a recent case. Last fall, a district manager for Warner Chilcott, or a former district manager, pled guilty to a HIPAA violation, interestingly, and this had to do with having instructed sales representatives to access patient confidential information at physicians' offices and prepare insurance authorizations for the physicians to sign so they could get coverage for a new and expensive drug. This did not go over very well, and while Warner Chilcott was actually convicted of, some of the other sales personnel were convicted of kickback violations in connection with this conduct. This district manager pled guilty only to a HIPAA violation and ended up having 8 months of house arrest, a year of probation, and a $10,000 fine.
Hey, Carolyn, what have you seen thus far? You know, I noticed that these are all 2016 enforcement actions. So is it kind of too early to draw any conclusions with respect to, you know, in the new administration, you know, kind of what their stance might be? Or are you kind of seeing this trend continue? Great
question, and the trend is continuing. There have continued to be settlements that we've seen, you know, right up through the spring at least, of 2017. So I don't think this one has died down, but of course, you know, those things would have already been in process under the prior administration. So I'm not aware of any announced policy changes. So we'll have to wait and see. Another thing I should mention is that there are state laws as well that if you're violating HIPAA, you're probably also violating. So, or could be. So there are, in addition to the civil penalties that we've discussed, the criminal penalties, the SEC monitors disclosure about products, and related, particularly in the medical device industry, to HIPAA, although a different issue, is the cybersecurity issue. You may have just seen Abbott announced a recall of 465,000 pacemakers to basically upgrade them with a security patch. This is a pacemaker that's implanted in your body. You have to go into your doctor's office and basically get the thing switched off for 3 minutes so they can upgrade the software. And this is following a year or so of, I think there was a warning letter from the FDA. This has been a pretty big deal in the cardiovascular space. So I just completely lost the slides here. I'm going to hand the clicker over to Diana, and she's going to fill us in on the GDPR. So I apologize for this. I did want to just mention before I do that that there are several bills pending on medical device cybersecurity. They're beyond the scope of this conversation. And without further ado, Diana, thank you.
That was great, really helpful. So I'm going to talk now about the General Data Protection Regulation, which is probably on some of your radars and probably not enough people's radars, but the GDPR is the newest law in the EU that regulates the use of personal information, and it's a significant departure from the current, well, actually it is the current law, but it's not yet being enforced. It will be enforced starting in May, but it replaces the Data Protection Directive. The Data Protection Directive was just that. It gave direction to the member states of the EU, all 28 member states, It gave them direction on how to treat personal data. But they then had to all pass their own laws that dealt with personal data and doing their best to comply. Well, the GDPR is pretty novel because it essentially is the direction and the law itself. So it was passed all at one time. It went into effect in all the member states, and enforcement will start in May of 2018. So the effect of it, the reason why it was passed was to give more uniformity in the various member states of the EU. It was a very lobby piece of legislation, and it's a very hotly contested piece of legislation. A lot of people say that it's the European Union's attempt to basically export their privacy regime to the rest of the world. So, you know, and you'll see why in a minute. But basically, the old rule was the Data Protection Directive said that if you were established in the EU, you had facilities in the EU, or if that was a central market for you, you were required to comply. And now, if you process personal data of EU citizens and you simply offer goods and services to EU citizens, so that could be a website where you can access it from the EU, or you monitor behavior of EU citizens, so think clinical trials. If you do any of those things, then you are now subject to the GDPR, and you have to treat personal data the way the European Union does if you want to have access to that data. So you're probably subject to the GDPR if you do clinical trials using data from the EU, if you have employees in the EU, because you're going to be processing personal data, obviously, of those people to pay them and so on. If you're marketing to the EU, like I said before, if you just have a website that reaches globally, or and you process personal data on behalf of an EU entity. So the other big change is that the GDPR applies to data processors, not just to what are called data controllers. So even if you're basically just dealing with data on behalf of a bigger organization that's making decisions about the data, you still have an obligation to comply with certain key aspects of the GDPR. Couple things I want to say about the GDPR and health data. So the GDPR does define health data, which the directive did not, and it says that health data is data related to the physical or mental health of a natural person, including the provision of healthcare services which reveal information about that person's health status. So, for example, even the fact that someone saw a medical care provider could be considered health data. And the GDPR says that health data, genetic data, and biometric data are all sensitive personal data. And sensitive personal data is subject to a heightened scrutiny in Europe. And therefore, getting that information to the US, there are more obstacles. So how do you do it then? How do you process sensitive personal data if you're getting it from the EU, and that's kind of a vital part of what you do? Well, the baseline rule is that you can't process sensitive personal data. So you need an exception, and there's a couple of key ones. Many entities rely on explicit consent, or the consent exception. You can also import data or use data, process data in the EU when it's in the vital interest of an individual, when it's done for scientific research or in the public health, and when it's necessary for the practice of preventative or occupational medicine or medical diagnosis. So a couple things on these. The scientific research exception, which I know will apply to a lot of you, does require that the various entities who use it pass or implement safeguards to protect that information. So depending on what the information is, there need to be data security and measures in place to protect it. The GDPR also allows local member states of the EU to, and this is one area where you do get discrepancy between the member states, so there's not as much uniformity as possibly envisioned when the GDPR began to take shape. They can require various safeguards. So you may see that people start to kind of forum shop or state shop, member state shop, depending on what various states require as the GDPR comes into full practice. I think that's all I'm going to say on that for now. Consent forms under the GDPR. So consent, again, is the major way that a lot of life sciences companies are going to be dealing with things like clinical trials and processing data there. But consent is now quite enhanced under the GDPR. It has to be freely given, specific, informed, and an unambiguous indication of a data subject, that means the person whose information you're using, wishes, by which he or she makes a statement of clear and affirmative action, signifying her agreement to the processing of her personal data. So for example, you click on an I consent button, you fill out a form, but you have to take some affirmative action. The other thing is that consent can be withdrawn at any time, so it has to be very easy to withdraw consent. And essentially, this is just an enhanced consent requirement. So the old forms you had under the directive are not going to work under the GDPR. Couple of things that you need to know. So I talked before about how the scientific research exception had various things that it required, that you had to implement specific safeguards. Some of those things are abiding by principles of data minimization. Anybody who's dealt with principles of privacy law in Europe know this is a big catchphrase. Data minimization, or using the least amount of personal data that you need for any given purpose. So one way you do this is by doing what's called pseudonymizing data, giving a pseudonym instead of a name to a given data set. So instead of Joe Blow, you have person A. Instead of Jane Smith, you have person B. In some regimes, like when we talk later about safe harbor, which is how you get data from the EU to the US, pseudonymizing data is considered basically making it no longer personal data. And so you don't need to even worry about the safeguards, but not so with the GDPR. The GDPR says essentially that if you could re-identify the individuals without, say, superhuman effort on your part, then that pseudonymized data is still personal data. So I would say you want to err on the side of calling pseudonymized data personal data and get all the protections in place, make sure you've got your exceptions in place to process it. Unless, like I said, it's virtually impossible to re-identify individuals, to put them back with their name, or say the data set are not so unique that there's only a few people that it could apply to. The other thing is that and keep in mind this is all brand new. So scientific research it says in the language of the GDPR that it's meant to be a very broad exception. But there's a lot of things that aren't clear, like will it apply to commercial research? So if you're using health data, but you're doing it primarily for commercial gain, then this exception might not apply. So scientific research is not defined under the GDPR exactly. So here are some general requirements for any company that is subject to the GDPR. So that their data protection by design is this idea that you incorporate into the product that you're rolling out some protection for the information that the product requires. So as you design an item, you think about how will this, if there is information that needs to be taken into this device, for example, how is that information going to be protected? So thinking about protecting data from the get-go. Also, a data protection impact assessment is increasingly a really important tool. It's also something that HIPAA, that the Office of Civil Rights likes to see. So looking at, if you're rolling out a product, for example, seeing how that's going to impact people's privacy rights and people's private information. The data protection impact assessment is only required if you process health data on a large scale, but most of you on this call, if not all of you, if you are subject to the GDPR, you are processing health data on a large scale. So a small scale would be a single physician's office, for example, or an attorney who has, 100 clients. You're not talking about a systematic operation where you're processing health data. I think anything else than that, particularly given that you're talking about a kind of sensitive personal data, you want to err on the side of getting these protections in place. And again, you see this requirement when you're monitoring individuals or health data on a large scale, then you also want to get a data protection officer in place. The penalties are quite significant under GDPR. They go up significantly, and they're large. Penalties are up to about 21 million, or about 4% of annual turnover for a company. And you have to report breaches of data if there could be a high risk of individuals. So, for example, if data is there's exposure, say somebody like a laptop was stolen or something like that, but the data is encrypted, you're not going to have to report that, but otherwise you would. So in sum, you want to determine, does the GDPR apply to your organization? And if it does, you want to take a look at your overall data protection regime and say, is it going to pass GDPR muster? That's sort of a longer conversation than we have time for today, but we've talked about some of the elements here. Have you established a valid legal basis for processing sensitive personal data? These are just basic things you want to check off. Have you updated your consent forms to comply with GDPR? Are you using key-coded data or pseudonymized data? And if so, have you done an analysis to see whether that's going to be considered personally identifiable information under the GDPR, or if it would be so hard to relink it to an individual that it's really not personally identifiable information anymore and it falls outside of the GDPR. Have you implemented the appropriate policies and procedures to ensure data protection by design? Are you carrying out privacy impact assessments? And if you're just a data processor, can you carry out your obligations? So even data processors have to comply with the GDPR when they export data to the US, for example, or in the kinds of records that they have to keep. So they don't have all the requirements of a data controller, but they have quite a few. And then just briefly, I'm going to talk about exporting personal data of EU citizens to the US, because I imagine this is highly relevant for a lot of you. So what the GDPR says is that there's no exporting of personal data to non-adequate jurisdictions. And most jurisdictions in the world are not adequate, according to the EU. So, and the US is certainly not adequate. There's 11 countries that are adequate, and the US is not one of them. So exporting data without something else, personal data without something else in place is not allowed. So you've got to have either a specific exception, or what they call in Europe a derogation, or you've got to have one of these three elements in place. You've got to have model contracts, which are essentially language that is handed to you, that you put into your agreement with the organization who's receiving your data, and it says exactly how you're going to use the data. And in some ways, they're a simple instrument, but they're highly narrow. And so they're not very flexible, and they can be really onerous because you have to get many, many model contracts in place if you're using data for different purposes. The binding corporate rules are basically a set of rules that different corporate entities agree upon how they're going to treat data, and it allows for a lot more flexibility than model contracts, but it can take 2 years to get them approved. It's quite a process, and that's problematic. Finally, the Privacy Shield, as a lot of you know, is what replaced Safe Harbor in the US, and that is the mechanism by which a lot of larger companies in the US get their data. And it basically is a process of self-certification where the US says we comply by certain data principles data protection principles, and we enforce those principles in a certain way, and there is now more teeth to it than there used to be, and then they can then receive data. The problem with the Privacy Shield is that its features uncertain. The safe harbor, which was in effect for many years, was invalidated just 2 years ago, and Privacy Shield took its place, and whoops. And so it's really not quite clear what is going to happen in that area. So I wanted to say something on Brexit. So I just thought this was interesting. Eric asked me about this when we were practicing. I thought I would just include one slide on it. So if the UK leaves the EEA, as you know, the UK is scheduled to leave the European Union in about 2 years. And if the UK also leaves the European Economic Area, then data exports from the EU to the UK are going to get very complicated. So if any of you have, for example, a major headquarters in the UK, you have headquarters in the UK or a major office there, and you have other employees in other parts of Europe, getting their data or getting data from them into the UK will get very complicated because the UK is not going to automatically be an adequate jurisdiction. As I said before, that's a hard, it's a hard thing. It's a hard test to pass, and the UK actually has current practices in place, making it a more sort of quote-unquote liberal data protection regime than a lot of other EU countries, and so it would need to do some cleaning up of its practices to be deemed adequate. So it would have to pass something like the GDPR and amend other practices. And if it doesn't, if it's not deemed adequate, then data imports from the EU are going to be prohibited into the UK unless there's a specific exception that applies, like the ones we talked about during this presentation, or you implement an appropriate mechanism for importing personal data, like the model rules or the binding corporate rules. And I'm going to now turn it over to Eric. Oh, I'm sorry, and I did want to say one thing on the assessment tool. So we did this presentation at Mayor Law Group, a similar presentation a few months ago, and if you go to the website and you do /assessment, there's a tool on there that takes about 10 minutes to fill out, and it's analysis of your privacy regime. It goes through HIPAA, it goes through data exports, and you can get a score essentially at the end of it. If you want to send it to me and have me look at it, I'd be happy to do that for you.
Excellent, thanks, Diana. I just wanted to spend the remainder of our time here kind of talking about the implications of some of these data privacy issues with respect to the board of directors. Starting kind of broadly, before we kind of jump into data privacy and cybersecurity, the board's role in overall risk management, it's one of oversight, right? It cannot and should not be involved in the actual day-to-day risk management of the company. It's more a role of oversight, ensuring that the company, has appropriate policies and procedures, that those policies and procedures are being implemented and functioning appropriately, and overall that the board and then the company itself is fostering a risk-aware culture within the company. And kind of taking that broad duty of oversight with respect to risk management, how does that actually kind of play into cybersecurity and data privacy? I think at the outset, it's very important to point out that unlike other areas of board oversight, financial accounting, traditional risk management issues, et cetera, this is certainly a new and rapidly changing area. As the GDPR rolls out, as other initiatives. Just last week we heard about the breach that occurred with Equifax, which we'll talk about momentarily. So it's definitely a rapidly changing area of risk management. I think that makes it a little bit of a moving target and one evolving target as well, requiring a little bit more of the board's time. And I think the other point as well is, it's difficult to, appropriately oversee this stuff without actually kind of getting too far in the weeds. And so there's kind of a delicate balance there as well. And just to kind of bring this home as well, we're in front of public companies often, and we do hear that this is a pressing concern to them, but it should also be noticed and noted as well. and Caroline, Diana hit it as well, that data privacy and cybersecurity issues are becoming of the foremost interest to various state and federal regulatory authorities, private parties as well. And here's the quote from the SEC commissioner a couple of years ago, talking about the importance of the board's role in overseeing management's efforts with respect to cybersecurity, and ultimately, protecting companies, their consumers, and investors as they relate to the risks associated with these issues. From a legal framework, where does this duty of oversight derive? It's a case law developed doctrine under Delaware law under the Caremark framework. So originally arose out of the concept of that directors owe a good faith duty to the company, and so under Caremark, a liability can attach to an individual board member where either the board member fails to implement a system or control, or having implemented such system or control, the board member consciously fails to monitor or oversee that system's operation. It is quite a high legal standard. We'll talk about that momentarily, about the efforts thus far to impute liability and how those have largely failed. But that is the background of the genesis, if you will, of the duty of oversight owed by members of the board. And so how do these typically play out? The sort of archetypal fact pattern, if you will, is that a company will suffer a large data breach. Then the shareholders typically bring a derivative lawsuit. Just as a refresher for those who it's been a while, or for the non-attorneys on the phone, in a derivative lawsuit, a shareholder asks the company to sort of bring a lawsuit in its own name. So the lawsuit is actually filed on the company's behalf against individuals. Typically, again, kind of echoing those two prongs of Caremark, the allegation is that the company, or specifically the board, they failed to take appropriate steps at the outset to protect data or to prevent data breaches. And I think that this last concept as well is one that we might see going forward is, not only that the data was failed, that the board, failed to properly protect the data or prevent breaches, but then also kind of the response and the recovery associated following the data breach. It should also be noted that in a derivative lawsuit under most states' laws, and this includes Delaware and California, a corporation is prohibited from providing indemnification to individuals for judgments or settlements of that lawsuit. So while a company would, for example, be allowed to indemnify individual directors for their defense costs in association with defending a suit, in the event of a settlement or a judgment of that lawsuit, and again, conceptually, this is the company bringing an action against its own board member, it's prohibited from then indemnifying for that settlement or judgment. It's kind of conceptually, it's a robbing Peter to pay Paul type of situation, and so that is prohibited by substantive law. And the plug here is this is when your directors and officers liability insurance can be crucial, particularly what we would call the side A, or the non-indemnifiable loss portion of a directors and officers policy. Some recent examples on here, again, kind of like following this fact pattern, where there was in fact derivative litigation following the data breach. Target, Home Depot, Yahoo. I will also note on Yahoo, there was, in addition to the derivative lawsuit, there was a securities class action filed as well. I will talk about that momentarily. Wendy's and Equifax. And as I alluded to, although this is definitely sort of a hotbed of litigation, and it's one that's growing in my estimation, to date, these derivative lawsuits have largely been unsuccessful. There is a slight exception in Home Depot. That case was dismissed initially. The plaintiffs there took an appeal, and it did settle on appeal for a payment of $1 million and change of plaintiff's fees, and also some prophylactic go-forward corporate governance reforms. Why the derivative claim is particularly difficult is that there are substantive procedural hurdles in filing this, right? So because effectively it's the company itself bringing the lawsuit, under Delaware law, before you file this, you need to make a demand as a shareholder to the company, asking the company to conduct an investigation and ultimately to bring the lawsuit. And that that demand is often typically denied by boards because they're not particularly inclined to file a lawsuit against themselves. And that denial is in turn subject to the business judgment rule, which is very deferential. So it's a very high procedural hurdle for plaintiffs to clear. Alternatively, to actually making a pre-lawsuit demand, plaintiffs can plead something called demand futility, which is effectively telling the court, because of these conflicts of interest on the board, et cetera, were we to have made a demand, it would have been futile because they would have denied it outright for sort of untoward reasons. And consequently, we effectively didn't need to make a demand on the board. Again, largely these suits have been dismissed for these procedural reasons. I apologize as we get the slide back up, as that is a high threshold. The one thing to note here is that in addition to the derivative lawsuits, you can have securities class action exposure. So these are where shareholders as a class, these are public companies now, are bringing action as well, alleging typically some violation of the laws governing the securities. Usually that doesn't happen because there's not a lot of movement with the company's share price. So typically as these become a little bit more commonplace, unfortunately, the shares of a company don't often move, and so consequently there's not a lot of loss or damages that you would have plaintiffs' attorneys alleging in the shareholder class action. There are a couple notable exceptions with Yahoo, and I'm going to talk a little bit more of the details of that breach and the fallout there shortly. In Yahoo, there was a shareholder class action filed, and actually there has already been a shareholder class action filed with respect to the Equinox or the Equifax breach. And then I'll talk about that a little bit as well momentarily. In addition to possible, liability as a result of a derivative or shareholder class action, there can be other fallout from a large breach. Certainly in the case of, reputational harm or actual loss of directorship. So I found this example, particularly telling. In 2004, following the breach that Target was the subject to, ISS, a very large proxy advisory firm, they had actually instructed and recommended shareholders to vote against the re-election of 7 of 10 of Target's 10 directors. So here, these were the directors who were actually sitting on the audit and the corporate responsibility committees at the time of the breach. And effectively, ISS, as demonstrated in that third bullet point there, made some pretty strong accusations that the board and these specific committees, were inadequately prepared for the risks of doing business in e-commerce, and that their failure to, properly ensure that management was addressing these issues, caused significant losses to the company and shareholders. So ultimately, that initiative was unsuccessful, but it's interesting, again, these issues are of utmost concern to a litany of participants. So how does a board member go about actually kind of fulfilling this duty? As I said, it is a high legal threshold with respect to the derivative litigation, but nevertheless, I think it's important that board members are aware of, kind of what they need to do. And I think the other thing to note as well is that thus far, these various derivative lawsuits have been unsuccessful, and they've been very large companies that were subject to breach. And my suspicion is, to the extent that a smaller company is the subject of breach, where maybe they didn't have sufficient controls in place, these lawsuits might not have been unsuccessful. So 2 points at the top. I think these issues need to be addressed proactively and regularly. It's kind of unclear what regularly means, but I think at minimum it's something that should be discussed, multiple times throughout the year. It's not just an annual thing where you check the box. And specifically, board members need to really understand the exposure and the threats that are faced by the company. Specifically understanding what data is at risk. Is it, personal health information, under HIPAA or otherwise? Is it more in the flavor of a company's own intellectual property? Is it source code, trade secrets, financial info, et cetera? So understanding what the potential risk and exposure is, and then consequently ensuring that there's an appropriate framework in place to manage the risk associated with that. And typically, this is thought of in kind of three parts or four, depending on how you're counting. But one is preventing, understanding the risk and preventing a risk, then detecting a breach if that has occurred, and ultimately. And again, I think this last point might be particularly important kind of moving forward is once a breach has been detected, how is a company responding to that and recovering from that breach? Certainly, it should be noted that these are all case-by-case discussions, and the facts will likely vary greatly. I do think there's a couple of lessons from the Target litigation. In this instance, Target, pursuant to this was actually under Minnesota law, it was litigated, but Target instituted a special litigation committee to kind of respond to the derivative demand, et cetera. And the special litigation committee conducted an extensive review. I think it lasted something like 21 months. So it was quite a lengthy process, and it was conducted by, independently appointed members, non-interested parties. And the special litigation committee found a couple of these factors, important, and ultimately concluding that the directors had, in fact, discharged their fiduciary duties. So one is that there was pre-breach policies and procedures in place to establish, data security and privacy controls. Additionally, interestingly, they found that the existence of network security insurance that had mitigated some of the cost of the breach, again, that factor that was already in place, they found that instructive in deciding that the directors had discharged their duties. There was pre-breach vendor security procedures in place, and ultimately, this was ultimately conducted at the employee level as well. Again, I think these factors will probably vary greatly from case to case and kind of depend on the facts there. But certainly, I think a telling roadmap for companies, broadly speaking. And that being said, there's some interesting empirical studies here. I realize we're running up against the hour, so I'll keep it moving. But despite the prevalence of these issues and the high profile, some of these studies show that they're still not really receiving board level attention with the frequency that you might expect. And so here's a couple of recent studies by both the New York Stock Exchange interviewing over 200 audit committee members, and also a PricewaterhouseCoopers as well. Both of these found effectively that the boards are not getting, addressing these cyber issues with the regularity and frequency that you might expect, having done so only occasionally or approximately once a year. Just briefly as we wrap up here, the other interesting thing is, particularly for public companies, is, how cyber risks and data privacy issues must be addressed before Securities Exchange Commission. So in 2011, the SEC put forth some guidance with respect to the disclosures around these. And ultimately, it requires that incidents be disclosed publicly to the extent that the cost or consequence associated is material, or it's reasonably likely to have a material impact on a company's operations, liquidity, or financial condition, or lastly, if it calls into question the validity of previously reported financial information. A couple issues there, I think, just momentarily, is that this is only guidance. It's not binding. It's yet to have been the subject to a major enforcement action, but we'll talk about that in a second. And also, the word material, which is crucial in this instance, that is undefined. So it's a bit unclear. There might be some leeway for companies to make various arguments with respect to whether or not a breach or a threat of a breach was in fact material, and consequently whether it needed to be disclosed. Interestingly enough, however, more and more companies are proactively getting ahead of this and describing cybersecurity as a risk in their financial disclosures. So here's a recent article from Bloomberg just about 6 weeks ago, noticing that just in the first 6 months of 2017, 436 companies had identified cybersecurity as a risk factor in their filings versus 403 in all of 2016. 305 and 15, and interestingly in 2010, so just prior before the SEC guidance took effect, only 8 companies had actually made such disclosures. As I mentioned, the SEC has to date not brought an enforcement action around the cyber security disclosures. That being said, they are conducting an investigation into Yahoo following its breach. Interestingly, in the case of Yahoo, there were 2 large breaches, and the issue here is that both of the breaches were disclosed publicly sometime, multiple years after the breach occurred and after Yahoo first learned of the breach. And so the SEC is, I think, understandably looking into whether or not the apparent delay had violated these reporting requirements. And with that, I think I'll open it up to Christina to moderate some formal Q&A. Thank you.
Thank you, Eric, and thank you to all of the speakers. We did receive 2 questions. One of the questions we will respond to offline. It's an administrative question. The second question is, can you address the derogations available for EU-US data transfer, in particular for employees and clinical trial information? And Carolyn and Diana will respond to this question.
Yeah, so this is Diana. So I'm assuming that that's both, so that's employees and clinical trial as 2 separate things. Clinical trial information, you would have consent and you would have scientific research would be the major derogations that could apply. For employees, you could also argue consent, but consent is a very suspect derogation for employees because the EU says that essentially if you're working for somebody, you're forced to give consent to give them your personal data in certain situations. So probably a more solid derogation to rely on would be to argue that that it is required pursuant to a contract or a legal agreement, which is another derogation. So for example, you could send over information on hours and address and things like that so that you can process payroll. Getting information outside of that purpose, you probably have to go with consent, or you'd have to find a means around transferring the data. And I'm just going to leave it there because it's 11:03.
Okay, well, thank you everyone for joining. And as I mentioned previously, if you have additional questions, feel free to contact the speakers directly. That information is at the end of the slides.